Angeline Falk, welcome to the programme.
Thank you for having me, Sarah.
Optus says 2.1 million customers have had their data stolen. Is this the biggest breach of private data we've ever seen in Australia?
It's the biggest breach that we've seen since 2018. That was when the Notifiable Data Breaches Scheme came into operation, and that requires any entity that's subject to the Privacy Act to report to my office if they suffer a data breach that can result in serious risk of harm to individuals.
Now, in this case, Optus was required by the law to notify your office of the breach. Have they provided you with enough information?
They have notified my office, and they also notified the public, and they've been emailing and SMSing affected customers. So we know from today that of the 9.8 million Australians affected, 2.1, as you've said, have had an identity document affected. That's information like your passport number or a driver's licence, and for a smaller number of Australians, Medicare information and other identifiers. It's important that we have this granularity of information so that government can assist Optus to respond to this breach, and also that entities across the economy can put in place additional controls to protect their customers from identity theft and fraud.
Now, given what you've heard from Optus so far, are you going to launch an investigation yourselves?
So this is a fast-moving situation. We are continuing to receive information from Optus, as well as the Notifiable Data Breaches Scheme. Optus also has a proactive obligation to secure the information of Australians. They have to have in place reasonable steps. So I'm seeking information about what security was in place at the time that this breach occurred, and I'll assess that information and decide whether further regulatory action is warranted.
Now, Optus has said they brought in external investigators. Is this a way for Optus, in a way, to dodge the obligation to tell people immediately exactly what happened and how it happened?
I think it's reasonable to have in place an investigation to work this through, and then what will happen is that I'll seek access to that information and we'll assess it as the independent regulator.
One more thing that the Optus CEO said today was that they're working with government departments, organisations and more than 20 licensing authorities. That sounds like a chaotic system for something that is essentially predictable, that is cyber theft.
There are a range of government agencies that need to be involved here, and driver's licences, for example, are issued by state and territory roads traffic authorities. So there are a number of players here. As the regulator, I've got Optus's consent to share the information that I've received around the breach with other government agencies that have a need to have this information.
I guess what I'm asking there is, that's a lot of people. Is there no system or no legal apparatus in place to centralise all of this so it isn't such a complex world that they're faced with?
Well, the centralisation happens through regulatory cooperation. So I'm working with the Australian Communications and Media Authority, as well as the ACCC and Department of Home Affairs, to make sure that we have a joined-up approach to any of the regulatory levers that might be pulled.
Why was Optus holding so much data?
That is a very good question, and everyone should be aware that under the Privacy Act, businesses are only able to collect necessary information. So they have to collect only the information that's reasonably necessary for their functions and activities.
And do you think that this set of data that they were holding goes beyond that?
That's a matter that we need to look at further. So there will be legislative and regulatory obligations upon telecommunications providers to collect certain information and retain it over a period of time. We're working that through, but the message is that, of course, collecting information can be a benefit. It can create innovation and economic value. It can also create a risk for the economy and the community.
And that brings me to the concern that people hold, obviously, as the internet and the Internet of Things gets more and more complex. How exposed are Australians' identities in commerce and in government services?
Well, as you've said, we are really dealing with an economy now that is digitised, and all businesses need to make sure that they have in place the right protections for Australians' personal information. So we trust these entities every day to give us goods and services, and in return we provide our data.
Should we be doing that?
Well, we need to be discerning. We need to check who we're dealing with, look at their privacy policies and notices and make a decision about whether to engage. Sometimes it's not possible to make a choice and we need to engage with these entities. And that's why, from a law reform perspective, I've recommended to government that there should be a positive obligation on all entities to handle data in a fair and reasonable way. And that shifts the obligation on individuals having to navigate these privacy policies, and it means that they can rely on the fact that the entity is actually dealing with their information in a way that they would expect.
And what about smaller organisations? Because obviously small companies aren't obliged to hold data in the same way that very large companies are. Is that something that needs to change, that this regime should apply to all companies across the board?
Yes, well, currently all organisations with an annual turnover of 3.1 million or more are covered by the Privacy Act, and private health service providers. But I have recommended to government that it's time to relook at that small business exemption. We can see now that even very small businesses can hold vast arrays of data. You can develop an app in a garage and suddenly you've got millions of Australians' personal information. So they should be required to secure it in the same way as big companies. And of course, it's a scalable obligation. It's reasonable steps. It depends on the sensitivity of the data that an organisation holds and the risk that attaches to it.
So I think the government has said they're looking at bringing forward a new privacy regime. What are the most urgent changes that need to be put in place in light of this attack?
I think the Attorney-General and others are talking about increasing the penalties under the Privacy Act. I do think that that is timely. We need to have a deterrent that's more than the cost of doing business. Currently, I can seek civil penalties to the Federal Court of $2.1 million, but overseas there's penalties as large as 4% of global turnover. And I think that that's the kind of penalty that we need here to make all boards and directors sit up and take notice of the very important responsibility they have as the custodians of Australians' personal information.
It looks like this Optus event is going to be a before and after event for Australia. Thank you very much indeed for joining us.
Thank you, Sarah.